Hello again, everyone, and welcome to Quigley on Divorce, a behind-the-scenes look. I'm your host, James Quigley. Thanks for joining. This is our fourth episode of 2023, and if you've seen the first three episodes in the month of January, what we really talked about is just the initial stages, getting going, getting on your feet, making 23 a year of action, right? Getting the inertia out of our lives, getting things moving and moving in a positive direction, taking all of those months or years of processing and turning that into action. And we kind of walked through, I think in the third episode was geared more towards, we've gotten past the thinking about it. We've actually called, had a consultation, and hired Quigley and the Beermann team. And from that, in episode 3, we talked about what are some of the general things I need to understand. What do we do then once you've hired us? How do we create a strategy? What are the things we're looking for? It's issue spotting, right? And then once we've identified the issues, we come back with a plan and say, here's how we're going to achieve your goals, how we're going to get you to that place where you want to be. But as I mentioned at the end of the third episode, what I want to do is step back, because in future episodes, we're going to take various issues within a divorce, and we're going to walk through those issues and really drill down in a more detailed way based on, for example, if you are in a fight over children and parenting time and decision making, those are issues I want to explore in a vacuum. If a spouse in a marriage is thinking about relocating to another jurisdiction, what is that? That in and of itself is an issue we will discuss. When we get into financial issues, child support, maintenance, that alone can be an episode because there's so much wrapped into that. Division of assets, marital versus non-marital. Business ownership. We have a good staple of our practice here is representing business owners or spouses of business owners. Years back, we had a business law group within the firm. Some of those lawyers kind of melded into our world of divorce, but we have that great institutional knowledge, and as such, we have, and it's been a big staple of our practice, business owners, and understanding business valuations, income from there, and valuations and how that gets distributed. So all of these issues moving forward, I want to nail down, drill down, whatever you want to say, issue by issue, so that as you go through the process of this year and listening to these podcasts, I can pick and choose, here's the issue on relocation. I really want to understand that better, and we're going to give you some of that information. But as I said at the end of number 3, before any of this gets started, when you call me and say, listen, my marriage is over, we've tried counseling, we've done everything we possibly could to save the marriage, I need to move forward because the marriage is over. All right. I'm having a consultation, I'm talking with you, I'm trying to understand what the issues are, and in that conversation, you mentioned to me, I have a prenuptial agreement. Amazing. Okay. Because at that point, pump the brakes, because as soon as you hire me, the first thing I need to do with my team is break down that prenuptial agreement and analyze, is it valid and enforceable? And please understand, there's statutory authority here in the state of Illinois for prenuptial agreements and the enforceability of them. It is extremely, extremely difficult to throw out or invalidate a prenuptial agreement in Illinois if they're done properly and if they follow the statutory requirements. So if you're at a point where you're not contemplating the breakdown of your marriage, you're contemplating the start of your marriage, that's what we're talking about today. Because if things don't work out and you are calling me for a divorce and you've got a prenuptial agreement, that might very well eliminate a lot of what people fight about. So I'm going to give you some tips, giving you free advice. These are things, if you go and you talk to another lawyer to help you with your prenuptial agreement, great if this is helpful. But you start from the standpoint, as I said before, a valid executed prenuptial agreement with the proper disclosures, 99 out of 100 times, maybe more in the state of Illinois, is going to be upheld. So the question then becomes one of really two things. One is the substance of the agreement itself, and the other is the procedural formation of the agreement. Is this done properly? Does this agreement, as formed, comport with all of the requirements of the statute? Now, as I said earlier, invalidating or challenging a prenuptial agreement, very, very difficult. I've had some success in doing that where the prenuptial agreement on its face creates such a hardship. And I had this one where the parties were married 27, 28 years, and it was, my client literally got nothing. So here would be a woman in her mid to late 60s, no ability to earn income for herself, after a 28-year marriage was going to get nothing under the terms of the prenup. And we successfully argued, tried the case, that created such a financial hardship that it was inequitable and should not be enforced by the court. And they accepted an argument. Now, my client didn't get assets. The individual was worth tens of millions of dollars, but was able to get a continuing stream of income that allowed her to live very comfortably for the rest of her life. So there are certain things, even if the overall agreement is enforced, you still might be able to challenge. So if you're on the other end and you're saying, I want the prenuptial agreement because I have a business or I have assets or I have tremendous income that I'm bringing into the marriage I want to protect, you better make sure you get your agreement done properly. And one of the surefire ways to invalidate a prenuptial agreement is if you don't do any disclosures. It's required. You better have exhibits attached to your prenuptial agreement that detail, to some degree of detail, what assets you have, what your net worth might be. It's a good idea maybe even prior to the marriage to produce tax returns to the other side as part of this negotiation. You want to make sure that you can exhibit clearly by documentation that you have reasonably apprised the other individual, the prospective spouse, of your assets, of your wealth, of your income. Why? Because then they know what they're getting into. They know what they're signing on for. They know you're worth $20 million and you make $2 million a year. And you're saying in this agreement, as long as we're living together as a married couple, you're going to enjoy that lifestyle. But guess what? We may incorporate into that prenuptial agreement a waiver of maintenance. Meaning, if we get divorced and I'm still making $2 million a year, if we had been married for 10, 15 years and I was making $2 million a year and didn't have a prenuptial agreement, you'd be getting maintenance. But we agreed 10 years ago, you're not going to. Now, that goes to some of the substance of the agreement. But the drafting of the agreement is very, very important, right? We want to comport with the statutory requirements. Disclosures, huge, huge thing. We want to make sure we have proper signatures. Do we have the document? I've got a case that's being challenged. The document itself, I'm going to actually rethink this. Maybe I shouldn't talk about this because I don't want to give the other side my secrets in terms of how we're going to bust that prenup. But be sure that if the document itself requires certain things, that those are performed, whether it's a signature on the bottom of each page, whether it's a witness to the signatures. Not every document needs to have multiple witnesses or being notarized. But again, I'm a belt and suspenders kind of guy. You want to do the things, if it's a little bit extra, but it just gives you a little more security, why wouldn't you do that? Why wouldn't you have the attorneys to that agreement sign off on it? Or have a separate witness, like you do a will or a trust, right? So drafting the document in compliance with statutory requirements is the first and most important part because that goes to its enforceability. Now, once you understand the mechanics, the skeleton of the agreement, what the substance is entirely up to the two people negotiating that agreement. You can put literally whatever you want. Now, what does that mean? You may have heard of some cases where people put in these clauses about infidelity. If you cheat on me, you get nothing. Now, some of you might sit and think, you know what, that's a great idea, because maybe it provides a disincentive for my spouse not to cheat on me. Well, I don't know that I've ever drafted a prenuptial agreement with that type of provision in there. Why? Not because I don't think maybe that wouldn't disincentivize someone to cheat, but because you've now opened an entire can of worms for litigation. If you say I'm not giving anything because you cheated on me, you have to prove that the person cheated on you. Illinois is a no-fault divorce state. So in a divorce, you don't have to, it's zero consequence whatsoever in terms of child-related issues, in terms of financial issues. If somebody was unfaithful in the marriage, doesn't matter. If you interject that issue into your prenuptial agreement, you've now created a litigation issue. And one of the whole purposes of a prenuptial agreement is trying to think today, how can I craft an agreement that avoids litigation in the future? How can we predetermine the what if? That's one of the main purposes. It's like doing a trust as part of an estate plan. If I die, this is what happens. My heirs, my family, they don't have to go to probate court. They don't have to fight about this. They don't have to have a will contest. No, it's already predetermined what's going to happen. And that's ostensibly what we try to accomplish in a prenuptial agreement. So, going back to the issue of maintenance, can you put into an agreement and it be legally enforceable that a spouse in the marriage is entitled to no maintenance if you get divorced? Absolutely 100%. Would I ever recommend that? No, I don't. And you say, well, wait a minute, why would I want to agree that if we get divorced to give her maintenance? Because you don't want to create a reason to litigate like I litigated in the case where my client was barred from receiving maintenance. And after a 28-year marriage, that created such an inequity, such a hardship that as a matter of public policy, the court found that provision was not enforceable. And it just created months and months of litigation, lots of attorney's fees, and it just ended up costing the individual more in the long run. Whereas had they said, you know what, let's have a reasonable provision that says, for an example, doesn't have to be this, but here's an example of things we've done. If, for example, parties are married for a certain number of years, at X number of years, provided that this person who has the wealth and the income going into the marriage is making a certain amount of income or higher, then the other spouse gets X number of dollars a month for Y period of time. Okay? It's something that under a prenuptial agreement they may not otherwise get. So, and by the way, I've done it where the longer you're married, the number goes up. Because we're understanding that after 28 years of marriage, the ability for someone to come in and challenge a prenup changes. So and if I have great wealth that I've accumulated over 28 years, let me at least hedge my bet so there's no litigation. I know what, the real exposure could be on the high side. I've mitigated that. So it leaves a soft landing and people can go on, they can live comfortably. And by the way, in the 28 years, that was the shocking thing about this. The case I had, they had 2 children. So imagine being 2 adult children and their mid to upper 60-year-old mother was now going to be in a position of being destitute. And their father is worth $20 million. You never want to be in that position, right? Not for your children, it's the right thing to do. And more importantly, it's what we're talking about. You try to create scenarios that disincentivize people to litigate. One thing we do in our agreements oftentimes to try to disincentivize people from litigating and challenging the prenuptial agreement is put a clause in there that says, If you challenge this prenuptial agreement, you pay your own attorney's fees. In a regular divorce with no prenuptial agreement, the law provides for interim attorney's fees, allows for one side to go in and at some point be able to go and say to the court, hey, I need you to order him or her to pay attorney's fees because I don't have control of money, I don't have access to money, and I'm entitled to reasonable representation as well, right? We want to level the playing field. Courts aren't going to allow one side to steamroll the other because they can get the best lawyers, the biggest firm, and the other can't even hire a lawyer. But if going into a marriage, two parties say, you know what, absent us having children and there being child-related issues, because you cannot bar someone from receiving maintenance if there are child-related issues. But if it's just two parties got married, we have our financial issues, we have a prenuptial agreement. In that context, you could put a provision that says you are not entitled to have me pay for any of your attorney's fees. So that can be a very powerful provision within an agreement to try to disincentivize the other side from litigating. Again, that's the point of a prenuptial agreement, is to say, God forbid our marriage doesn't work out. We recognize that I came into the marriage with this, and that if things don't work out, and you go your way and I go mine, here's the plan in place that governs what that looks like. A judge doesn't tell us what that is. Lawyers don't litigate what that is. It's already predetermined. So, in fairness, I should say to you that oftentimes, as lawyers, we look at prenuptial agreements as a starting point to litigation. If someone comes to me and is on the receiving end of a prenuptial agreement that is very unfavorable to them, and they're in a very precarious position coming out of the marriage, I'm going to look at every angle I can possibly look at to challenge that. And anybody that knows me and knows my willingness to try cases and litigate may look and say, listen, you might spend a lot of money fighting. Even if you don't have to pay her fees or his fees, you're going to have to pay my fees. And so are we better off negotiating maybe something that's a little better than what's set forth in the prenuptial agreement? Hey, you're doing really well. You've during the marriage, your business has gone up, your wealth has gone up, your income has gone up. Why not maybe put a little more on the table to make this a fair and equitable agreement and to avoid litigation? Because as much as I'm in the business of being paid for what I do, I would love for people, my clients, to not have to spend a lot of their hard-earned money and assets paying me if there's a reasonable path to a resolution short of litigation, short of spending a lot of money. So always consider that. Again, in a prenuptial agreement, you cannot negotiate away future issues related to children. So just know that. If you're married and you have this great prenup and then you have children during your marriage, it's going to open up, I don't want to say Pandora's box, but it certainly is an issue that if litigated, you may end up having to pay the attorney's fees for, and you can't predetermine, hey, if we have children, I get custody. I get control of them. They live with me. I don't pay you child support, or you pay me X number of dollars in child support. Can't do it. So always remember, children are just a carve-out, and you go into a marriage, and if you're blessed with having children, it could potentially be a litigation issue. But again, even in a regular divorce, we try to keep the kids out of litigation. We try to help parents reach agreements. And the truth of the matter is, too, if you are someone with great wealth, great income, and you have children, even if you have a prenuptial agreement that is somewhat oppressive to your mother of your children, well, do you want to be in a position where you're really arguing to keep that person destitute? Because then that also impacts the standard of living of your children as well. So it's not an end-all, be-all when you do a prenuptial agreement and have children. Understand that. But it's certainly certainly, if you have assets or wealth or significant income coming into a marriage, it certainly can afford you some protection. Because the other thing is, if my assets are off the table based on the legality and the enforceability of that prenuptial agreement, then you don't have the right to dive into discovery and subpoena everything and to go into my books and records. It's legally irrelevant. Now, you have to think these things through. Sometimes, despite your best efforts, today, thinking about the what ifs, 10 years from now, 20 years from now, things may be different, things may be changed, right? But you also want to always make sure if you do a prenuptial agreement, you look at it, you follow it. From time to time, go back and say, hey, listen, we're about to buy a property. What does the prenuptial agreement say if I buy that property in my own name? Or if I use this source of funds to buy it versus that source of funds, could I be potentially converting that from a non-marital asset into a marital asset? Okay. What does your agreement say if you buy something jointly? And let's say you buy something jointly during the marriage and $200,000 comes from one spouse in something that was clearly non-marital. Do they get that $200,000 reimbursed before the division? These are things that have to be spelled out. So usually when you do a prenuptial agreement, we stay away from boilerplate, hey, what's yours is yours, what's hers is hers, nobody gets anything at the end of that, good luck. Because you're going to have a fight, you're going to have a challenge, and being on the side of trying to enforce an oppressive agreement, could really put you in a bad light. So try to think through as many as the what ifs as you can, talk them through with your lawyer. And again, from a lawyer's perspective, I need to understand what is it that you're really trying to protect. It's no different than when you call me for a consultation in a divorce, and we're saying, what is it that you're trying to accomplish when you come out of this divorce? What is it that you're looking for in terms of financial security? What is it you're looking for with respect to the kids? We do those same things in a consultation, in a meeting, in a prenuptial agreement. What is it trying to protect? I've had clients who come to me and say, you know what, I just have this one asset, and I just want to make sure everything else we go in, we get married, and what's ours is ours together. But this one asset, I want to make sure I protect. Well, the reality is you probably don't even need a prenuptial agreement. If we can identify that asset as yours, you have documentation of it, you never say it's a piece of property. It's in your name, titled in your name. And you hold that through the entire marriage and you never, ever change title. And then you go and sell it. Well, you sell it during the marriage. Those proceeds you put into a separate account. Spouse's name isn't on that. So he's going to be non-marital. And it's just a question of documentation. So that's sort of an aside. If you choose not to do a prenuptial agreement, hear this. This is great free advice right now. If you're about to get married and you're not going to do a prenuptial agreement, and you have a retirement plan, you have a savings account, you have an investment account, you have a piece of property. Number one, and many people these days don't do this, print out hard copy statements. Have your closing documents from the purchase of that property. Do not ever put that property into joint tenancy with your spouse. Always keep it in your name, even if you refinance it, okay? Maintain that document. Believe it or not, I've had some clients that have saved themselves because they hung on to documents for 20 years. They got the file cabinet in the basement. Oh, yep, here it is. Wow. You just enabled me to, because it's our burden. If you are asserting something to be non-marital, you have the burden of establishing that through some kind of evidence. And banks, institute financial issues, some of them will go 10 years, sometimes 7 years, but you may not be able to reconstruct evidence, documentary evidence of the existence of something prior to the marriage, unless you've kept it. So you're thinking about getting married now, you're hearing this podcast, and you're saying, there's no way my spouse is going to agree to a prenuptial agreement. I'm not even going down that path. And to be honest, I don't really want it, but I am concerned about this property I have or this account I have. Number one, Get that statement. Number 2, open up a separate account the day you get married. That account that you had prior to the marriage, you freeze it. You never put another dollar into that account. And that money, as it grows, it's not touched. You can pull money out and spend it as you want, but no money's going into that account. It's always non-marital. And from day one of the marriage, I've got this different account. My paycheck goes into that. It's always going to be marital. Everything that I'm earning, again, assuming you don't have a prenuptial agreement. So that's just an aside that if you're not going to do a prenuptial agreement, at least do yourself a favor. Get a safe deposit box. Get a safe in your house, whatever you need, and you have that documentation in a folder for a rainy day. That if ever there comes a day where the marriage is broken and you're getting a divorce, at least you've got proper documentation of the assets you owned prior to the marriage. And you've got documentation to show that I never did anything with it. There was no commingling that occurred. I never put marital assets into that. I never put a spouse's name on title to that. Doesn't mean you can't, in an estate plan, say, if I die and we're happily married, guess what? Those accounts I had before the marriage, I'm going to bequeath those to my spouse. Still do that, and that doesn't change the marital nature of it. But it's planning. It's really planning. And my job with clients, whether it's going into a marriage or coming out of a marriage, is to help you plan. It's to create a strategy. It's to make sure you're protected. We always, again, before marriage, after the marriage, we're always trying to find ways to help you avoid litigation. Litigation's ugly. You know, I'm a good trial lawyer. I've tried a lot of cases in my 30 years, and we've been successful. Part of why we're so successful in trying cases is the skill and understanding of how to try a case, but a lot of it is avoiding the cases you shouldn't try. It's okay from time to time to have, it's a close call, you know, but the upside to the fight is so worth the fight that let's go in, and if we end up, you know, going down, we're going to go down swinging, okay? But generally speaking, if we're in a negotiation and there's a reasonable position on the table, and any experienced lawyer knows what the parameters are, and you're always arguing within the margins. And usually the dollars litigants are spending on those margins just isn't worth it. So when there is a reasonable deal on the table, like I dealt with in 2 or 3 cases at the end of the year, where we had the hard conversations with the clients, where we're saying, look, you're not going to get better at trial. You're going to spend more money going to trial, and the amount of money you're spending versus what you're fighting is not going to be worth it. And it's hard because at the end of the case, after a year, 2 years of litigation, litigants have spent so much money that the deal, had the other side been reasonable, had the other attorney been reasonable, we could have gotten that deal done 6 months after the case was filed. You wouldn't have spent hundreds of thousands of dollars in legal fees because all that money is now gone. It's wasted. And so the deal that actually would have been a pretty good deal 6 months ago, 12 months ago, 18 months ago, now doesn't seem so good, but the deal's not going to get any better going to trial. So pick your battles. And again, the theme of today is, hey, how can I avoid the fight before I'm even in a position of having to determine whether there's going to be a fight, right? And that comes from premarital planning. Prenuptial agreements are a very effective vehicle to do that type of planning. It's a tough sell. Got a lot of clients, represent and work with a lot of agents that they'll give really good advice to the athletes they represent. Man, you just signed this huge contract. You need to protect this. And they've got to have that conversation with their fiance. Doesn't always go real well. You know, you could imagine someone say, you just signed this $30 million contract and you're telling me you want to marry me, but I'm going to get nothing? Tough conversations. And you have to, as much as possible, you try not to make it personal. Try to focus on the business aspects of it. And you hope that going into a marriage, everyone's respectful of, I'm going to take care of you if things don't work out, but I'm not going to open up Pandora's box. for you to come in and say, I want, $15 million and I want, $40,000 a month in maintenance for the rest of my life. There's going to be some reasonable controls on that. So tough conversations to have, but in the long run, if something doesn't work out in your marriage, you're really going to be glad you did that. And guess what? If you live happily ever after and you have a great marriage, because everybody goes into a marriage loving somebody and thinking that we're going to grow old together, and that happens. My folks are going to celebrate this year 64 years of marriage. Not everybody gets to 64 years of marriage, but if you are blessed with a long marriage, the fact that you did a prenuptial agreement is never, ever going to matter. It's a safety valve. So consider that. And really, consult with a lawyer. If you're getting engaged, just got engaged, don't wait and call me and say, oh, by the way, we're getting married next weekend. Can you do a prenuptial agreement? We can. Oftentimes we'll say, I could, but I'm not going to do that. This is not, I don't want to get involved in trying to, a week before the wedding, have that situation where we're handing a document the day before to someone. So give yourself time to plan, have enough time for both sides to process through the emotional aspects of it, have reasonable negotiations, and then put it to the side and say, okay, now we've got a couple of months. Let's just get back to being in love and have a great wedding and hope that we never, ever have to even pull that out of the safe, okay? So, but plan. And if you have any questions, again, call me, 312-621-1225. You're going to hear that every podcast. jmquigley@beermannlaw.com is my email address. Email me. 2 E's, 2 N's in Beermann, right? Or Quigley on Divorce. You're going to look at my social media. DM me with questions. Hey, could we schedule a call? Sure. Happy to talk to you. Happy to give you some general direction. And if you choose to hire me, we'll put the team together. We will make sure that you're protected. That's our job. So give it some thought. Not right for every marriage. Even when you might be advised by a financial advisor, a sports agent, a family member, maybe your parent, hey, you have to get a prenuptial agreement. You really need to do this. Think strongly about it. It's hard, it's tough, it's uncomfortable in the short term, and it may not matter in the long term, but if things don't work out, you'll really be glad that you had that pre-planning and you were smart and you were businesslike about it. So for those of you that are listening about this and you are about to get married and you're engaged, God bless you. Marriage is a wonderful thing. And, as much as I've been a divorce lawyer for 30 years, I believe in marriage. And I really, really hope that even if you work with me and get a prenuptial agreement, you never, ever get to use it. So, again, if you need to reach out, do so anytime. Again, 312-621-1225 or jmquigley@beermannlaw.com is my email address. But otherwise, good luck to you. And we will then, moving into the 4th episode for the new year, we're going to start to work into individual issues. We're back to saying, okay, called Quigley, got things moving. I finally made the decision to move forward, hired a lawyer, sat down, developed a strategy, but we've got all these issues. So what do I need to know about these? And we're going to get into the various issues along the lines of child-related issues, financial issues, business valuations, relocation, all kinds of things, attorney's fees, right? All of the things that happen within a litigation we'll discuss. And along the way, there's going to be times where, guess what, hot off the presses, a case came down, or we just got a trial verdict, or something happened, and we want to talk to you about various issues. I might, from time to time, bring back guests, as I've done in the past podcasts, to give a little bit of a different flavor, a different perspective from an expert, from a mediator. I've had some clients in the past that have been willing to join me. I never ask of that, I never push, but if they're willing to do that, I think an actual client who's gone through this or is going through that can maybe provide some perspective of what their experiences could be really valuable. So we'll try to weave in things like that But again, I'm always open to ideas as to things you might be interested in or want to know. There's so much to a divorce, and I understand that if you're just still contemplating a divorce, it's a lot to process. There's a lot of insecurity, a lot of uncertainty, but it's all things that I think with the right team around you, we can put you at ease so that you understand, here's the direction we're going, here's what we can accomplish for you, and that can give you a little bit of peace of mind going into what's going to be a tough process. So wish you all the best in the new year. Reach out to me anytime. Again, hope that you continue to join in at Quigley on Divorce, a behind-the-scenes look. We'll try to, again, bring you the kind of information that really could be helpful to you if you're in the process, thinking about the process, or even just coming out of the process. So be well and continued success in 23.